Hello, my name is Trey Worley. I'm going to talk to you about protection by patents. Bill Gates once said, intellectual property has the shelf life of a banana. In other words, IP is very vulnerable and we need to protect it. Patents are a good way of doing this. There's three types of patents. There's design patent, which is for things like furniture design or the shape of a Coke bottle. There's plant patents that scientists use for asexually produced plants. And utility patents, which are the most common. That's what we think of when we think of patents. They're for any useful process, product, or machine that someone wants to patent. Patents are important because they protect the rights of the inventor and the businesses from having their ideas stolen. And in turn, this encourages progression of technology, science, and business, and helps the overall economy. A quick history of patents. In the Constitution, there's a clause that gives exclusive rights to the inventor to promote progress of science and useful arts. The Patent Act of 1790 was the first patent act in America, and it established a first to invent basis. But 4 years ago, the America Invents Act passed, and now we're on a first to file basis. So it doesn't matter who invented the product first, it matters who got to the office and filed for it first. So in order to get a patent, you first decide what kind of patent you want to file for, design, utility, or plant. And then you create the patent file. Most people use an attorney for this. It's recommended to use an attorney, but it also costs a lot of money. Then you submit your application to the government. They examine it, which will probably take anywhere between 1 to 3 or more years. They have a lot on backlog to examine. There's currently 600,000 waiting to be examined. So it'll probably take a few years to get your patent through. Then you pay all your government fees, or if it didn't pass, you can resubmit it and pay more fees and try to get it submitted again and see if it passes. And then if you do get it passed, it's good for 20 years, and over the course of 20 years you'll have 3 payments that increase incrementally to maintain the patent, and those are over $1,000 each. So when it's all said and done, you're easily going to spend more than 10 grand on a patent. There's currently a couple legal issues in patent law, with one of them being non-practicing entities, also known as patent trolls. These are basically companies that acquire patents by either inventing them themselves or buying them from other businesses, and then what they do is they just hold the patents in stockpile and don't actually manufacture the products or use the processes that the patents are for. They just look and wait for other businesses to infringe on the patents they hold so that they can sue them, and this is how they make their money. So it's not helping anyone but that company, and it hurts the economy, and it also discourages innovation because other companies are afraid they're going to infringe on someone's patent that's not even being used. Another issue in patent law is basically where to draw the line from new inventions to improvements on current inventions. An example is the Apple versus Samsung case. They basically compared the Apple iPhone to the Samsung Galaxy, and Apple said that Samsung infringed on their patent of the iPhone. So what the jury did in this case is they said, are Apple's designs new or were they already around? They decided yes, they're new, they weren't previous designs, so the patents are legit. Then they asked if Samsung infringed on them. And basically, based off of visual layout, they held the two phones next to each other and decided yes, Samsung's phone looks too much like Apple's. They infringed on their layout patent. And also Apple's swipe to unlock patent, where you run your finger across the screen to unlock it. So in the end, Apple was awarded $1.05 billion, but injunction was denied, so Samsung still has the right to continue making their products. The Samsung CEO said, "It's unfortunate that patent law can be manipulated to give one company a monopoly over rectangles with rounded corners." So he's frustrated because he says Samsung was not copying what Apple did, they were just making it better. So again, where do you draw the line between a new invention and a variation or improvement on a current invention? But for this presentation, I'm going to focus on patent trolls. I chose to focus on patent trolls because I'm a business management entrepreneurship major, and I wanted to see how patent trolls negatively affect small businesses and startups. Also, I believe it's an unethical approach to making money, and it hurts the economy and innovation, and I think it needs to be stopped. So the way patent trolls work is they usually will attack smaller companies that don't have a lot of capital to pay for court fees, and they'll force them into settling by offering a settlement that's less than the court fees would be, and they make their money that way because most companies are going to settle instead of paying for attorneys and going to court. A patent troll example is the company Innovadio. Innovadio, they sued Cisco for the use of Wi-Fi because they bought this Wi-Fi standards patent right before it expired, and then immediately turn around and sue Cisco for giving Wi-Fi to coffee shops, hotels, and anyone else who used Cisco's routers. They sued Cisco for $2,000 per customer that used a Cisco router. And instead of just paying the settlement of $2,000 per customer, that would have been a lot of money, Cisco took them to court. In the end, Cisco paid 10 cents per site instead of $2,000 per site, but they paid $10 million in legal fees. So for Cisco, being a big company, the $10 million in legal fees was a nuisance, but it wasn't detrimental. But if Innovadio would have attacked each individual coffee shop and hotel like they tried to, then the $10 million would have been a lot more detrimental. One attempt to combat patent trolls is a bill that's circulating through the government right now called the Innovation Act. In 2013, it passed the House of Representatives with a majority vote from both parties, so now it's just waiting to be voted on by the Senate. The Innovation Act will make it harder for trolls to file suit against companies for patent infringement. It will accomplish this by many different ways, a couple of them being the transparency to ownership. So the patent trolls have to provide a detailed history of the patent and how it was acquired. They also have to give detailed claims for each infringement on each patent that each company infringed upon. And it redefines the interested party as a person and not the whole company. So the people that have direct financial interest in the patent are the few people whose names are on the patent itself, not the entire company. The Act also helps defendants by decreasing the court costs. For example, they limit the amount of discovery done before the trial. Also, it provides a higher chance for an earlier decision to be made so that the defendants don't have to pay the court costs of a longer court case. And lastly, it gives the defendants the right to recover the legal costs from the court case. So if they win, the patent trolls have to pay for some of their legal costs. So we've all heard that small businesses are the backbone of the economy in America. This is because they create a lot of jobs, they're very innovative, and there's a lot of small businesses. However, patent trolls target small businesses, especially tech startups, more than any other business. They do this because large businesses like Cisco often have enough money to go to court, and they know this. So they attack the small businesses because they have low cash reserves in the first few years especially, and they're more likely to settle instead of going to court. Remember the Cisco versus Innovadio case. Innovadio was trying to get each coffee shop and hotel to pay them $2,000 for using a Cisco router in royalties. And they knew that these coffee shops, for example, probably weren't going to take them to court because most coffee shops don't have that kind of money. So they expected to get the $2,000 royalty from each customer and then move on to the next case. But Cisco luckily stepped in to protect its customers. But since there's not always a big company to step in to help the little guys, here's a few ways we could reform patent law to help them. First off, we could have self-help groups, or basically an industry association that helps the small businesses decide whether or not they should respond to the troll claims. Because a lot of times the trolls will demand a settlement, but if no one responds, then they won't follow through with it because they have other court cases to deal with. Also, we could encourage court to sue the makers and not the users. So for example, those coffee shops that were using Wi-Fi, we could encourage the courts to not let the patent trolls have a case against them, but rather have a case against Cisco. And this would help make the cases go towards the large companies and not the smaller ones. Lastly, if we use the patent infringement as a gauge to see how it actually affects the patent troll companies financially, then we can reduce settlement royalties because most of the patent troll companies aren't financially affected by the infringement. They're just using it as a way to sue and make money. All in all, we'll give less power to the trolls and more to the small businesses. So in my opinion, we must stop the trolls, and we should also hope for Senate to pass the Innovation Act, as this will help. In conclusion, patents are important because they protect inventors and businesses and promote innovation. However, patent trolls are challenging this purpose, so we need to reestablish the protection by things like the Innovation Act and other ways that we can stop patent trolls and further foster innovation in America. Thanks for listening. Here's my references.